Welcome, everyone. We're going to begin shortly with our third Thursday training. Feel free to enter the chat. We always welcome you to state what office you're from, and if you want to state your role, if you're a prosecutor or victim advocate, but we always like to know who's joining us, so feel free to enter your information in the chat. We will begin in 3 minutes. Hi, Stephanie. I see we have Shannon from LADA, Mackenzie, and Mark, Elizabeth from Contra Costa, Kevin from LA. Welcome, everybody. LA is representing, I see. Hi, Norma and Chris. Angie and Christina and Lydia. And always, Hinako Jefferson, we always have you here. Glad to see you again. And Nick from Sacramento, welcome. Hi, Richard and Valerie, Maria.
Hello, everyone. My name is Adrienne Carpenter, and we're going to go ahead and get started today. Welcome to our third Thursday training, the topic being responding to ethical considerations in sexual violence cases. For those of you who may be new, welcome to the Prosecutors Alliance of California third Thursday training. For those of you who don't know us, like I said before, we are the first of its kind. We are a criminal, pardon me, we are a criminal reform-minded organization that places emphasis on reform prosecution efforts throughout the state of California and actually beyond the state. We actually reach all 50 states and at times have international members within our organization. For the presentation today, I'd like to introduce you to our presenter, Jane Anderson, an attorney advisor at Equitas. Jane Anderson is an attorney advisor with Equitas whose expertise centers around prosecuting domestic violence, sexual violence, and human trafficking cases. Prior to joining Equitas, Jane served as an assistant state attorney with Florida's 11th Judicial Circuit in Miami-Dade County. As a prosecutor, she's tried many of the state's first human trafficking cases, including related sexual assault, child abuse, and money laundering crimes. Before focusing on human trafficking, Jane served as the chief of litigation for the misdemeanor domestic violence unit. where she trained new attorneys and oversaw the prosecution of domestic violence, stalking, and violations of criminal protection orders. Finally, I will add that Jane also graduated cum laude with a Juris Doctor from American University, Washington College of Law, after earning a Bachelor of Arts in History from the University of Washington in Seattle. With that, I will turn the presentation over to Jane Anderson.
Thank you so much. And I'm really glad to be here. I'm actually live in Contra Costa County, California. So it's always nice when I'm presenting to a California specific audience. We've got a lot to cover today. I've made sure that the handout has all the information you'll need, and we're going to try to get through as much as possible today, but I do like to make it a little interactive. So we'll see where we get. I wanted to introduce Equitas to some of you if you aren't familiar with us. We are a nonprofit. We're based in Washington, D.C., although we all live all over the place. And we're funded through various streams of grants. And this presentation today is being supported by the Office on Violence Against Women from the Department of Justice. And they fund us to provide really innovative, informed, and hopefully practical strategies to prosecutors, law enforcement, and anyone else whose work intersects with the criminal justice system and domestic violence, sexual violence, stalking, and trafficking. So we do this by having training events like this one. Really glad to be partnering with the Prosecutors Alliance. We also have a ton of resources online, and we're available to do 24/7 consultations. Probably one of the favorite things that I do as an attorney advisor is help folks work through difficult cases, whether it be trying to figure out, do I make the charging decisions, maybe voir dire strategies, trying to identify experts that might help you with your cases, that kind of thing. So you can follow us online. We're always pushing out new resources and training opportunities. This is our caveat where we really want to thank this Department of Justice and the Office on Violence Against Women. So today we're going to talk about ethical considerations. So we're going to start with our charging decisions and how we can make those, applying the law, analyzing the evidence, and also considering our ethical duties under various sort of policies. Throughout this, we'll also talk about where does our ethical duty lie when it comes to victim privacy and victim autonomy. Because while we're not victims' attorneys, we serve the interest of our communities and our jurisdictions. And of course, the victims are within those. And then, of course, a big piece of ethics is always going to be focused on our due process and discovery responsibilities. So hopefully you guys have heard this before, because I think it's a mantra for those of us that have worked in prosecution. And one of the things that makes our job so important, so different, and really something that we need to come with humility and also a great responsibility, because our responsibility is not to fight for a client, but really to achieve justice. And what that means can be very layered. So we do this in a couple of different ways, right? These are our typical duties as a prosecutor. We make the filing decisions, we do document review, we enter into plea negotiations. Sometimes we're involved in investigations, and of course the trial and subsequent maybe probation violations or something like that as well. So that monitoring piece. But I bet you, as I see all of you guys on here, that a lot of you guys do more than that. And maybe things that are considered a little less traditional in our roles. And where do our ethical duties come from when we do things like communicating with our allied partners and participating in task forces or coordinated community responses, when we work with victims to connect them with services or make sure we're filing for restitution on their behalf. I'm sure many of you conduct trainings, cross training with your partners, maybe even conduct trainings or educational events with your community. And all of those duties are other things that we engage with regularly to help meet our greater goal of achieving justice and serving our communities. So, oh, I don't know what I missed a slide there. So what I wanted to do is start off with a little scenario, because this helps bring some of these ethical considerations to greater, I don't know, it makes them real, right? These are things that we're dealing with. So here we've got a case, this is our case file. So we've got a detective, Detective Hawkins. He's assigned a domestic violence investigation where the defendant, Alex Dumas, has been arrested on numerous occasions for violence against the same victim, Sam Lee. During a follow-up interview, the detective goes back and talks to Sam, and Sam says that during the relationship, Alex also forced sex. So legally, we're going to consider this what this described by Sam for this reasons of this hypothetical. Sam has described rape under California statute, California Penal Code. So they have disclosed this in a subsequent interview. Sam had never disclosed this rape to anyone else, but they tell you that they've missed work due to this violence. And they're able to provide the detective with dated cell phone photos showing bruises to their upper arms. Sam also says that also tells the detective that Alex Dumas has a Twitter account containing tweets and retweets of sexually degrading and violent content. So this is information that comes to us. So you guys, we can use the chat for this. We're going to go pretty quickly because I want to cover as much as possible. But if you've got some thoughts, please share them in the chat. Based on this information, can you as the prosecutor file rape charges where Alex is originally only arrested for domestic violence? So I'm guessing a lot of you are kind of like, can I versus should I versus would I? And so we're talking about the ethical universe of can I today. So can I is how we are guided. And so let us look at where we get our guidance from. We have the ABA's model rules of professional conduct, and Rule 3.8 in particular talks about special responsibilities of a prosecutor. We have, in addition to that, ABA's criminal justice standards for the prosecution function. And they are a companion piece to the ABA model rules, and they actually say within them that these rules are written to be entirely consistent with the model rules of professional conduct. They're a little bit more detailed, to be honest. And then we have the NDAA, or the National District Attorney Association's National Prosecution Standards. The State Bar of California also has rules of professional conduct. They don't have anything, as far as I could tell, that's specific to the prosecutor's function, but you always want to make sure you're compliant with that as well. So this is where we're going to be working. This is the frame of reference. So Maria asked, what is the evidence? So right now we're talking about Sam's disclosure to the detective. We're talking about some missed work consistent with the timing that Sam talks to us about, and we're talking about these cell phone photographs. So can we file charges? So this is looking at the ABA model rules. We say the prosecutor in a criminal case shall, and this is in the negative, shall refrain from prosecuting a charge that the prosecutor knows is not supported by probable cause. Which is interesting because I'm sure all of us probably use a different standard when we're talking about whether we're going to file charges or not. But this is how I wanted to ground ourselves, and this is what the ethical rules say, that it's probable cause, which I think some of you might be surprised at. The ABA prosecution standards goes a little bit deeper, and it says a prosecutor should seek or file criminal charges only if the prosecutor reasonably believes that the charges are supported by probable cause, that the admissible evidence will be sufficient to support a conviction beyond a reasonable doubt, and that the decision to charge is in the interests of justice. So here we have, again, the probable cause, and then also the fact that we have to look at admissible evidence, and that admissible evidence has to be sufficient to support a conviction beyond a reasonable doubt. Another place I just say, this is important to see how this phrasing is, because it doesn't say you believe you can, that a jury will convict. It says that the conviction would be a legal conviction and it would be sufficient to support a conviction based beyond a reasonable doubt. And they add this: the decision is to charge is in the interest of justice. And you guys know prosecutors' discretion to charge is probably one of our most awesome responsibilities, and where we have a great amount of discretion. A prosecutor, this is the NDAA standard, just to give you all of them here. A prosecutor should file charges that he or she believes adequately encompass the accused's criminal activity in which he or she reasonably believes can be substantiated by admissible evidence at trial. So we want to look at admissible evidence. That means we have to do an analysis of what statements are coming in. Crawford, is the victim going to testify? Is this going to come in as through some sort of exception to hearsay? Or is there a Crawford analysis that we need to do? That all has to be done in advance with our charging decision. Of course, sometimes we don't know. Those of you that are prosecuting, domestic violence or sexual violence out there, that victims are often, able to prosecute one day and then not able to prosecute another day for lots of really good reasons. And so that's kind of an added difficulty that we have to look at. We also have to look at search and seizure issues. Is this going to be admissible evidence, and the relevance of the evidence as well? So we might be thinking about the tweets that we know Alex is sending, maybe misogynistic, sexually violent tweets. Is that relevant to our case? Are we going to be able to put that in as admissible evidence? Taking that all together. Wanted to also bring up, and this is all a combination of the ethical guidance. I've sort of pulled it, and it's very similar to one another, right? This idea of our charging needs to be consistent with the interests of justice. And we need to be looking at things like the strength of the case, the extent or the absence of harm, whether there's violence that was perpetrated, the views or motives of the victim, the defendant's relative level of culpability in the criminal activity, their criminal history, the status of the victim, including their age or if there's a vulnerability, possible influence of some sort of cultural, ethnic, socioeconomic, or other improper biases, the impact of the crime on the community, and any other aggravated or mitigating circumstances. So I think we know that all comes to us fairly regularly. But I also wanted to point out the factors we are not to consider, and this is the NDAA standards. It says the prosecutor's individual or the prosecutor's office rate of conviction. I work with prosecutors all around the country, and one of the projects I've been involved with is the Sexual Assault Kit Initiative, or SAKI. That initiative is directly addressing the backlog of rape kits. So many of you probably have heard of that. You might be in offices that have done this work. There's a couple of grants in the state of California so that folks could not only, test these untested kits, but also look at, why did these kits go untested? Can we rethink how we're addressing sexual violence in our communities and our jurisdictions? And one of the things that we hear when we talk to prosecutors is, I don't think I could win this case. I don't think the jury would get this. And we know about the complexities of sexual violence, and that's not what this training is about. So this is something I always like to point out, is that we've been asked, do not consider our previous history of success when it comes to conviction rates, because we know that we haven't always actually implemented best practices or promising practices. And so if we haven't been successful, that's not indicative of anything of, rather than maybe we haven't used enough tools in our toolbox to do this the right way. So it says in particular not to look at that. There's a couple of other factors not to be considered, a lot of that going to bias and discrimination and political advantages. And this is the ABA's quote under standard 3.4.4. a prosecutor may file and maintain charges, even if juries in that jurisdiction have tended to acquit persons accused of the particular kind of criminal act in question. So I think when it comes to cases of sexual violence, this is a good thing to remember, is that even though these cases are so hard and challenging, we should continue to strive when appropriate to charge and prosecute these cases and not be over reliant on a history of maybe challenges. So now we're going on to the investigation, and Detective Hawkins calls you and asks you, hey, what do you want me to do to, investigate this case against Dumas, and you actually want Detective Hawkins to do the following. In your brain, you're like, go talk to those supervisors, go talk to the coworkers, talk to the supervisors. Let's go and review and identify the social media accounts. Let's maybe get those photos from Sam on the phone. We have all sorts of ideas of what we'd like to do, right? So the question is, can you tell the police what you would like them to do? And I'm curious if you guys, some of you may, I'm assuming, be on call, work really closely with police and investigations. We know that's a promising practice. The earlier the prosecutors are involved, the better investigations go, the less likely cases there's attrition between arrest and charging. But what, if any, ethical duty is impacted by this, or what are we talking about here? So we're actually talking about immunity, which is a little bit different from our ethical duties, but I think so intertwined, it was important to mention here. And so as prosecutors, we have absolute immunity for functions that are intimately associated with the judicial phase of the criminal process. Absolute immunity is a really safe place to work. That means that if somebody tried to sue us because we, filed charges, it would directly go outside of the court. Absolute immunity, really lovely place to be working. So these are some of the things that are intimately associated. These are the things that are those traditional prosecutorial duties. It does not include acting as your own investigator, giving advice to police during an investigation, attesting to the truth of facts or signing in support of an arrest warrant, or signing a search warrant. This comes from case law. Now, this is where sometimes when I present live, I get some like very worried big eyes opening, because most of us do give advice to police during investigations. Some of us have been taught to sort of couch it in some sort of hypothetical response, like, I can't tell you what to do, but hypothetically, this would be really great. I know that I worked with some prosecutors that did that. I sort of gave up the ghost when I started doing trafficking work, because it was just so imperative that we work together so closely. But what does that mean when you do act in this regard? That puts us in a space of qualified immunity. And it basically is what law enforcement officers work with. And it's a very high standard of immunity. So when we ask advice, we do police investigative work, even administrative duties. When the functions of the prosecutors and the detectives are the same, the immunity that protects them is also the same. So for most prosecutors I've worked with, our office in particular, we kind of were comfortable with working under qualified immunity. The benefits of us working more closely with investigators during our investigations, the benefits far outweighed the risk, because really qualified immunity is a very high standard. There's been a lot of discussion about that recently. But it's something kind of important to recognize, and something you might want to say, like, do we have an office policy on this? Do I know what our office's policy is on this? And the qualified immunity standard is that government officials performing discretionary functions generally are shielded from liability insofar as their conduct does not violate clearly established statutory or constitutional rights of which a reasonable person would have known. That's the current definition of qualified immunity. Okay, so thinking about that, can you conduct an online search for Alex Dumas? Can you go into your browser and Google him? Can you follow their social media accounts? Can you send them a friend request? Can law enforcement do that? What are the implications? What are we talking about? I have a no, please, no, coming in from the chat. So remember, we're talking about ethics and not necessarily best practices. But what's implicated here? These are the considerations. Would conducting an online search be considered investigation and therefore affect your immunity? Maybe. There's really no case law on this yet. Most people would say, yeah, an online search is probably safe to do, or ask your investigator to do it if that made you feel more comfortable. Is following a public account considered investigation, or is it maybe even considered communication with a represented party if that person has an attorney? What's the difference between following a public account, so you're getting notifications maybe when they post, and asking to be a friend? Do you think the courts would find one as communication and one not? And then the final thing I just put here is that some social media companies have terms of service that don't allow you to have undercover accounts unless you are you ask for permission as law enforcement. So if you're working with law enforcement that has undercover accounts, many of them do, something to maybe consider, is this something they've actually made sure they're in line with the terms of service? Because there are right ways to do it, and usually it is allowed, you just are meant to do it in the right way. Yeah, I love it. The difference between can you and should you, always a good ethical line of inquiry. So now we're at recantation. So you receive a call from Sam telling you that they do not want to testify against Alex. Probably familiar to everyone on this training right now. So you refer Sam to your office's victim advocate. Hey, why don't you talk to the victim advocate? Sam does talk to the advocate, and the advocate tells you later that Sam is afraid of Alex and Sam doesn't want to be involved in any criminal case. Sam told the advocate that if they were forced to testify, they would say nothing happened. Okay, so a couple of things here. What do you have to disclose? What do you have to disclose to the defense about this conversation? Hopefully everyone's on board. We just need to disclose this, right? This is an advocate. They're working for our office, and so their knowledge is imbued to us. They don't have a confidential relationship because they are what we call a systems-based advocate. That would be different from a community-based advocate who maybe does fall under confidentiality, and they wouldn't even have to disclose it to us. So these are the model rules about timely disclosure, that we are supposed to timely disclose these things. I won't go over this because I know we all do this. This is, hopefully, really knocked in our heads, that we should be seeking this information. We can't avoid information, and we need to turn it over. And let's see, these are all the rules. Like I said, you're going to have those. The timing, we should make all those, and we should not avoid pursuit of information because we think it's going to come to bad information. Okay, so now what if the defense has not invoked discovery? They haven't asked for discovery. Do we still have to turn it over? This is sort of a nuanced thing I like to bring up because I never thought of it this way when I was a prosecutor. But Brady and Giglio, although oftentimes they are written into our rules of discovery and our discovery obligations, Brady and Giglio are due process rights due to a defendant, whether they have invoked discovery or not. So that type of information has to be provided whether or not they've invoked discovery. Here's the case law that says that. So you would have to disclose all of that. Okay, so based on your review, you're looking through the prior cases, you saw this history. Based on your review of the previous cases between Sam and Alex, you believe that Alex has repeatedly intimidated, tampered with Sam during the course of their relationship. Probably seen some dropped cases, some no pros memos, some modification of pretrial release conditions. However, you guys know this is happening. And Alex has been incarcerated since the rape charges were filed. So Alex is incarcerated. You filed those rape charges. You've got the supporting evidence. We think Alex is intimidating Sam. So you go ahead and you listen to those jail phone calls, or you have the police or investigators do it. And you discover that Alex is in fact arranging for someone to pay Sam to drop the charges. The police want to continue listening to these calls because they want to figure out more about this plan. They want to figure out who's going to make the delivery, where the delivery is going to be, when it's going to be. So they want to keep listening. When do you have to disclose or provide these jail phone calls in discovery? This is interesting because I think a lot of us, I know that jail phone calls were some bread and butter of some of my human trafficking cases and my domestic violence cases. And you sort of have to balance this idea of, okay, I have new evidence. I'm probably going to file new charges. I'm going to want to bring this up in court. It's evidence of consciousness of guilt. Maybe I even have a forfeiture by wrongdoing hearing. So I need to provide them, but when do I need to provide them? So there's some considerations about that. You know, what is that discovery responsibility? Is the due process implication there? What is considered timely disclosure? And then one of the things to always keep yourself safe with is you can file an ex parte motion for a protective order. And that might be a way to say, hey, judge, this is the information. I'm not giving it to the defense right now because it's part of an ongoing investigation of current criminal activity. And this is the good reason why I'm not turning it over. And then you can sort of CYA by getting the court to sign a protective order that allows you to not turn it over until a certain time, or at a certain time, or after something has occurred. Okay, so now you informed Detective Hawkins about Sam's call where they spoke to the advocate and said they did not want to testify. Detective Hawkins locates Sam, and Sam denies ever calling the prosecutor. I didn't call them. I didn't talk to them. I don't know what you're talking about. However, Sam does reiterate that they do not want to be involved. So Detective Hawkins writes a report describing the calls and Sam's in-person statement. You provide this report in discovery. The defense now lists you as a witness, and probably your advocate as well, and asks the court to remove you from the case. What do you do? What if they list the victim advocate? I'd be curious if any of you have experienced this before. I definitely have. We had probably not so great practice of working on the weekends and calling victims from our phone as we sat alone in our offices and having conversations leading up to trial with our victims that were not witnessed by anybody else. And then I had to then disclose the contents of that communication because what I thought was maybe a status call turned into somebody disclosing something. And then the defense would say, hey, you can't be in charge, you can't prosecute this case anymore. So we're looking at ABA Rule 3.7a, the lawyer as a witness. And it says that a lawyer cannot act as an advocate at a trial in which that lawyer is likely to be a necessary witness, unless the testimony relates to an uncontested issue. So what can you do? There's actually a lot of ways around this, right? So basically you're making the argument that you're not a necessary witness and that this is going to be undisputed in the end. Because thinking about this, if Sam testifies, we're going to ask, right? Hey, Sam, did you make this call? And did you meet with this detective? If they tell the truth, there's really nothing to impeach. They're saying, yes, I made the call, and then I lied about it to Detective Hawkins because I just didn't want to I just wanted to not be involved. If they do not remember or they do not tell the truth, we can then offer a stipulation, or we can actually offer Detective Hawkins' report into evidence and offer that stipulation. And therefore, we're not a necessary witness. The evidence is before the fact finder, and we don't need to be involved. And therefore, you can stay on as the prosecutor. Can you call Sam to the stand if, based on this last conversation, which is, if you force me to testify, I'm going to say nothing happened, which we believe is a lie. So we have to first figure out what we believe, right? So we believe that Sam is telling us that they may lie. So this is the candor towards the tribunal, ABA Model Rule 3.3a, and it says we can't offer evidence that we know to be false, and that we have to remedy something if we learn of it. Except in a criminal defense case, that doesn't work. But then I wanted to go on and say, a lawyer does not violate this rule if the lawyer offers the evidence for the purpose of establishing its falsity. So we know for good reasons, victims of domestic and sexual violence may recant or minimize on the stand. It's a safety mechanism. There's a lot of reasons why that may happen. And sometimes it's our responsibility as a prosecutor that represents the jurisdictions in which we serve to continue to go forward on that case. And so we would maybe do something, we may impeach our own victim, our own witness. We may do a soft cross and try to basically, demonstrate to the jurors or the judge of why this victim is recanting. We may be using an expert witness to explain that. So that's a way that in these cases, especially since we frankly don't know. I've had witnesses who I thought were gonna say one thing, say the other, and we don't know what they're gonna say before we call them for the most part. So that does allow us within our ethical duties to make those sort of analyses. Okay, so I think this is gonna, well, yeah, we got a little time. During the investigation, the police took screenshots of various evidence from Sam's phone. So what are these screenshots of? We have angry texts between Sam and Alex on the night of the incident. Sam's angry with Alex for spending too much money out with his friends. Alex is angry with Sam for having a close relationship with a coworker. So we're getting a lot of information about what may have led to the rape, what may have led to any sort of violence. And then we have those photographs as well, the assaults and the rapes. The police did not seize the cell phone. In fact, they just took those screenshots. No forensic examination was ever conducted. The defense attorney has filed a motion to compel the victim's cell phone. During the hearing on the motion, the defense tells the court they believe the phone contains exculpatory evidence. The defense wants to engage a private forensic examiner to download the victim's phone. This comes up a ton nowadays in every sort of case that we have, including sexual violence cases, maybe particular sexual violence cases. Again, if you have seen this and you want to share in the chat, I'd be interested in how your judges respond to this. What are your arguments to the court when we have something like this go on? So it's a couple of things we want to be thinking about, right? First off, the rules of criminal procedure, they're mirrored in most states. Is this item within your care, custody, and control? If the police did not seize the phone and it remains in the custody of the victim has a right to privacy. And there is no discovery right from the victim, right? So it's not within our care, custody, and control. The victim has the right to privacy. The victim is not a party in the case, technically. And then the final argument is, the defense cannot just go on a fishing expedition. Imagine the chilling effect if the defense was able to just stand in court every time in every case that involved a victim and say, I want full access to that victim's phone. I'm not giving you any other information other than, I think there's some exculpatory information. So we're making arguments that we would make if somebody was looking for counseling records or medical records. The defendant cannot go on a fishing expedition. They must articulate a specific reason why they believe the evidence is necessary, meaning they can't get that evidence anywhere else, or exculpatory. So these are our arguments when we have these motions to compel. Here's a case out of Seventh Circuit. It says Brady prohibits the suppression of evidence. It does not require the government to act as a private investigator and valet for the defendant, gathering evidence and delivering it to opposing counsel. So I think this is where some of our tension points sometimes lie is to what extent are we required, especially when it comes to victims who have a countervailing right to privacy, and often there are victim bill of rights, or there may be other sort of ways that we talk about the rights that victim has that usually includes, being free from harassment and intimidation, and things like that. What if the police had conducted a forensic examination? And so the forensic examination, and Equitas does a lot of trainings on some really basic digital evidence for folks. We have one called #guilty that's about identifying, preserving and admitting digital evidence. And it's sort of like for the non-cyber crime people in the room. But one of the basics is that a forensic examination of a phone, you're going to get the whole phone. You're going to get the entire contents of the phone. Unlike a forensic examination of a computer, where you've got an examiner that has parameters that they're looking for, and they're basically taking stuff off of a computer, putting it in a report, and they're doing it fairly tailored to the investigative demands of the case. In a cell phone, which is why we call it a cell phone dump, it's a dump. So we get everything. And I think, with sophistication that may change in the future, but right now, for the most part, this forensic examination is going to give us everything on the victim's cell phone. If you can only imagine somebody downloading your phone and saying, hey, the only way we can go forward with this investigation is if you give me access to the entire contents of your phone. Chilling effect, but we know what happens. And sometimes in certain cases, it is the best way to go forward. In my trafficking cases, I'd sometimes had a phone where the entire phone is evidence, everything in there, because they're conducting their business, all that is on the phone. So let's say we do have that. We, of course, have to comply with our discovery and due process obligations. Discovery is material because one of the discovery responsibilities, is if the information is material. So it's material if it's sought, is relevant to the case, and will lead to the discovery of admissible evidence. So we have to look at relevancy, materiality, and then we can, and exculpatoriness, of course, and then we can make appropriate redactions. So my practice was always to make redactions as I felt appropriate, make sure anything I was redacting was clear so that the defense had the opportunity to make other arguments. So I always let them know I'm redacting this. It was very obvious, right? And then you can also ask for an in-camera inspection. Similar to this in Facebook records, I once had a case, it was 1,600 pages of a 16-year-old's Facebook. And the relationship between the victim and the offender was only a week-long relationship. So what I did is I provided everything that was sort of like a week out from the week and a week past the week. So I kind of opened the window of the time frame we were talking about. I conducted several keyword searches as well, and I let the defense know exactly what I had done to redact that for them. I said, these are the search parameters. I've given you everything within this time frame. I've searched all of these words and given you everything on that. And I even invited the defense to say, if you want me to search anything else, or if you have reason to believe other date ranges are relevant, please let me know. I made all the redactions, provided those. The defense, of course, argued they wanted access to the entire Facebook account. And in the end, the judge did do an in-camera inspection and came back and said, the prosecution has complied with their discovery and due process requirements. So that's always a great way to go as well. Okay, so after that, the police intercept Alex's plan to pay. They intercept Alex's plan to pay Sam to drop the charges. Sam re-engages with their counselor at the rape treatment center. Sam tells Detective Hopkins that they were only going to accept the money because they were getting evicted. And the eviction was due to Alex having someone destroy Sam's property and spray paint the house. You refer Sam to victims' compensation, and they receive money to replace their property and to clean up maybe the spray, I don't know. Your victim advocate connects Sam with a legal aid attorney who helped them win their eviction case. And the rape treatment center provided Sam with some clothing and a gift card to help them purchase groceries. You also drop Sam's open shoplifting case from the time when Alex refused to give Sam money for groceries. So the pendency of this case, Sam has a shoplifting case as well. So you've got a lot that you're doing, which is all really wonderful. You're supporting the victim in the case. We've got some victims compensation. We've got a referral. We've got some gift cards and groceries, and we're also dropping an open criminal case. So what all do we have to disclose of that? Big question. What, if anything, do you have to disclose? The victim's compensation. Most of the time, that is something that we would disclose because it comes through our office, and the documentation is something our office helps the victim with. That may be different in your case, but you want to be thinking about, does that go? Is that something that's discoverable? The referral to legal aid attorney. The clothes and gift cards from the rape treatment center, and the drop charges. I think the only one, the referral, I don't know how relevant that is, but I always sort of thought when I did these cases that it always benefited me if the defense wanted to bring this up in court. Because I was like, okay, well, let's talk about why we needed to compensate them, why we needed to make this referral, why we had to help this person give groceries. It actually sort of built into my case more of the sort of abuse and power and control that Alex held over Sam. So never really an issue. And the drop charges, of course, that is something we definitely have to turn over. The one caveat that I put here is that the Rape Treatment Center likely is a community-based organization, and a community-based organization that probably has some confidentiality where they would not have to disclose this. And so you may be able to shield discovery from these things. I don't think it's usually worth the effort, especially if I know about it, because then confidentiality has been pierced to the point that I know about it. But Giglio requires that we disclose any deals that we make to a witness, any impeachment evidence that we know the defense would have, and anything that's been construed to require disclosure of anything of value that's been provided by the prosecution team. So this is interesting case law. Thanks, Maria. Thanks for bringing that up, that California's victim compensation would not cover the property and only the person in this particular case. Good to know. So who is on the prosecution team? Who do we need to make sure we're aware of as far as, are they giving anything to the victim? Are they providing meals or gift cards? And this is a long quote from an even longer case out of California, but it's one of the ones that better describes who's on a prosecution team. This case is not particularly relevant to sexual assault prosecutions, but it does describe that a prosecution team can have many members with different responsibilities. But at its core, a prosecution team, those members have to perform investigative duties and make strategic decisions about the prosecution of the case. So merely interacting with the prosecution team without more is not going to make somebody a member of the prosecution team. So we have to think about, is this person engaging in the investigation? Are they acting under our direction? Are they crafting trial strategy? So when it comes to employees of our office, like our victim advocates, they work, it would be construed that they are part of the prosecution team. However, somebody that's working for a community-based organization would likely not be construed as part of the team, even if you're working as a task force. Okay, so I am going to kind of close out here before we get to this next piece. If there are any questions, I'll address them now, or I can just sort of move along and monitor the questions. If you want to chat me a preference, but I think this next little piece is quite interesting. So I'm going to go ahead until you guys tell me to stop, or if I see some questions popping up, please do that. So while listening to the jail calls, the police hear Alex tell their accomplice that Sam's going to be easy to convince to drop these charges. And Alex says, oh, Sam's even taken a charge for me before, when Alex was out on bond and the police came to the house for another DV incident. You review the police and court records and you identify a case that matches those facts. So you identify a case where Sam has actually pled guilty and taken a conviction on battery against Alex. But Alex is sitting there on the jail call saying, hey, Sam took that charge for me because otherwise I would have been in real trouble because I was out on bond at the time. So what should you do with that information? You have your victim well, first off, it's going to might be important for your case because that might be a defense that we should be previewing, who's the primary aggressor, that kind of thing, predominant aggressor, excuse me. But this is one of the other special responsibilities of a prosecutor, Rule 3.8 in the ABA. This is when a prosecutor knows of clear and convincing evidence establishing that a defendant in the prosecutor's jurisdiction was convicted of an offense that that defendant did not commit, the prosecutor shall seek to remedy that conviction. So that imparts on the prosecutor a proactive duty to remedy convictions when we have clear and convincing evidence. And I'm loving that a lot of prosecutors' offices around the country are implementing conviction review units and looking back and saying, okay, let's go back and review some of our cases. And that's completely in line with our ethical duties to do that. I think this is part and parcel of some of the work that we do through our Just Exits initiative on expungement and vacatur for victims of trafficking that were convicted of crimes that were committed under duress or while they were under the control and coercion of an offender. So kind of thinking more broadly about what our duties are retroactively is sort of something that I encourage folks to think about. Okay, so again, I'll take up our whole hour if I can. Just let me know. I'm monitoring. I don't see any Q&As yet, but I'm happy to stop if anyone says so. So Alex's defense attorney approaches you and gives you a counteroffer. You have previously discussed plea offers with Sam. While you've never discussed this exact plea, you're pretty sure Sam would be happy with the disposition. You can't contact Sam, and they were not expected in court. You didn't ask them to court that day, you were just picking a jury or whatnot, and you can't seem to get hold. So you're not sure if Sam will testify in the case. You're not sure. Last you thought yes, but you never know. And the judge is really pushing you, resolve this case or let's start picking a jury. Can you accept that plea offer? And what can you say if the defense attorney asks whether Sam will be testifying or not? These are like full on law school hypos. I hope I'm not giving anyone PTSD here. So obviously a prosecutor should not knowingly make false statements of the law or facts in the course of disposition discussion. So we should be honest about our last conversations with Sam, or whatever the truth is, we should be absolutely honest if asked about whether Sam should testify or not. And then these are the victim's rights, and they include, of course, being involved. This is under the federal definition. I know California probably has something like it. We should be making sure that the victim is apprised of the plea. We should not be accepting a plea without, and we should be, making sure that the judge who's trying to pressure us to do this, that we're letting the judge know for sure that the victim has every right to hear of that. Okay, so I'm going to go to the very end. I see we have some questions. So let's ethically charge these cases, comply with discovery, uphold victim rights. We want to do all that. And I'm happy to answer any questions. So I see Todd says, did your former office have a conviction review unit? We did not, but we work with several offices that do. So if you're interested, I'm happy to make a peer-to-peer connection with you. My contact information is here, and we can get you in touch with another office that does it and learn more about it.
All right, and Jane, we also have two questions that came through in the Q&A section. So the first question that we have is, you spoke earlier on about ethical charging and charging based upon someone's conviction record. And an attendee has asked, who in their right mind would file based upon a conviction record? Are there any cases that we can use as an example of that particular method?
I think I was maybe saying the opposite. I was saying that a lot of places would decline to file charges because they feel like we can't win this case. So even if there's the evidence, there's definitely the probable cause, we have this admissible evidence, there's a victim disclosure, but maybe the victim was drinking during the sexual assault. We've definitely worked with offices where if you look at their stats, they're going to look and you're going to say they've never filed an alcohol facilitated sexual assault in the history of their office, or haven't in the last 5 years, because they lost a series of these cases before that and they just stopped thinking they could ever win them. So that's what we're talking about by not relying on a conviction rate history.
All right, and we have another question, and that question is going to be, what about community-based advocates who do not fulfill 1035.2 qualifications regarding immunity or qualified immunity? Can they still claim the privilege by virtue of saying they are community-based sexual assault counselors?
Okay, so this can be very specific to statutory construction. So I am happy to follow up with you. But what I think you're asking here is, where does that confidentiality come from with the sexual assault counselors, and where does it break down between a systems-based counselor who's working for a law enforcement department embedded in a DA's office, their pay comes from the prosecutor's office. Usually they are not going to have a privileged relationship with victims in that case. I've seen a rare exception where there's been some carve outs, but typically that's going to be something that there's not going to be a privilege. On the other hand, folks that work for a community-based rape treatment center or any other service, victim service agency that's an NGO, even if they work with law enforcement regularly, if they're an NGO, they typically do qualify for that confidential privileged relationship. But if you, again, want to reach out to me, I'll do a statutory analysis for you, and I'm happy to give you a very specific answer according to California statutes.
All right, so thank you so much for that. We're going to go ahead and stop sharing, and we will finalize this with some last housekeeping issues. We're going to say thank you for attending today. We really appreciate it. We're also going to ask that everyone complete the survey that we have. That survey is going to be essential to actually getting out your MCLE credit. Join the Prosecutors Alliance if you can, and thank you, and possibly attend the next training. Once we end this session, you will automatically receive the survey, and we will definitely be sending out MCLE certificates in the conclusion. Thank you so much.
And Adrienne, do you know what our next February training will be on? What's the topic?
Yes, the next February training that we have is going to be presented by For the People. For the People is an organization in California that essentially helps people develop a prosecution review team, and they also do the work in-house. And so we'll have Carmen Nicole Cox, who is an attorney. She's actually the deputy director for the People, and she will be here with us in February on our third Thursday training. Thank you so much.
Thanks, everyone. It was a pleasure.